The last matter to come before the court this morning is Elizabeth, and please forgive me, Szefcyk versus Joseph.
Kucirek and Judge Stoll.
Kucirek and Judge Stoll. Thank you. Counsel, I will note that we were to commence this at noon. Is there any reason that we cannot go forward a little bit ahead of the schedule this morning? We're not waiting on anyone else?
That's fine, Your Honor.
Thank you. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
Thank you. May it please the court, my name is Brett English. I represent the appellant, Elizabeth Szefcyk. I would like to reserve 3 minutes of my time for rebuttal, Your Honor. Your Honor, this is a straightforward case involving allegations that the police officers in question recklessly injured my client in the course of effecting a search of her residence where she was not the object of the search at all. The record is extremely limited by the fact that we have a complaint and an answer, and a motion for summary judgment, and a brief in opposition to the motion for summary judgment, and no evidentiary material whatsoever other than the initial pleadings in the case. So based upon that, the complaint alleges that on a specific date, my client, living in Amherst, Ohio, but in her own home, was there when a number of police officers, including the 2 defendants in this case, showed up at her door unannounced and unbeknownst to her and wanted to conduct a search of her house. They did so pursuant to a search warrant that had been issued by the court. She was not the object of the search, she alleges, although that's denied. But the reality is that she was not the object of the search. There had been an armed robbery at a delicatessen on the west side of Cleveland. And Mrs. Szefcyk's live-in friend, Mark Hogue, H-O-G-G, was alleged to have committed that robbery. In fact, this is outside the record, so I'll just say this, that he was tried for this crime. He was found not guilty of the crime. And in fact, he was nowhere near Cuyahoga County on the date of the incident, but nevertheless, that was part of the investigative process that took place, and there was, in fact, a search warrant, and that's not the issue in this case. When Mrs. Szefcyk opened the door, she was immediately handcuffed. She was wrestled to the ground. She was placed with the handcuffs behind her back in a very tight way. She was in a nightgown. This was at night. And then she was left on the ground, hog-tied like this for approximately 15 minutes, as the complaint alleges, until another police officer from the city of Cleveland realized that she was in great distress and picked her up and loosened the handcuffs. The allegation in the complaint is that as a result of this conduct committed by these 2 defendants, she sustained permanent neurological damage and needed 2 carpal tunnel surgeries and is still in pain.
Did she resist in any way the entry after knowing of the warrant?
Absolutely not. In no way, there's no allegation that she resisted in any manner. There's no allegation at all. She was simply handcuffed, presumably for officer safety. We don't dispute that the officers had the right to handcuff her under the circumstances. Whether that was necessary or not is certainly another question, but legally the officers were within their province to do that. That's not the issue. The issue is whether or not this injury happened as a result of this, we allege, unreasonable handcuffing in the manner that it was done, for the duration that it was done, resulting in these injuries. The defendants filed an answer in the case. They alleged that they didn't know about a lot of things. They alleged that somehow they denied that she was not the object of the search, although I think Mr. Petticourt would concede the point. I think that was just an error.
Whether or not she's the object of the search goes to what, the duty?
Well, no, Your Honor, it doesn't. I don't think it's relevant at all.
Okay.
Even if she was the object of the search, but just in the context she was handcuffed in such a way that that she was injured, and there's a lot of case law on the point, which is cited in both of our briefs, indicating that if you unreasonably handcuff someone in this manner, that is potentially a tortious act.
Which is, I guess, which is more than mere negligence?
Yes, Your Honor. Obviously, statutory immunity in this case was asserted as a defense, quite properly. 274403 would prevent a recovery from mere negligence in the case. So in the complaint, there is a specific allegation that the conduct was reckless. There's an allegation that the conduct was malicious by virtue of the fact that she was handcuffed for such a long time in the manner that she was. And there's an allegation that it was a willful act. As the court is well aware, 274403A6 contains A6 subsection B contains an exception to the statutory immunity or political subdivision immunity. We've called it statutory immunity in this case, just so that we're on the same page. We're talking about political subdivision immunity. There's an exception for individuals, even if they are acting within the scope and course of their employment, from having immunity in the event of reckless conduct. That is the allegation in the complaint. That allegation is denied in the answer. And that is the basis for the motion for summary judgment that was filed in this case. Basically, what the defendants allege is we're entitled to statutory immunity. We don't have to demonstrate why. We are entitled to a presumption of immunity, and therefore the burden shifts to you, even in a summary judgment context, to establish why we're not. My response to that is, it is the burden of the person seeking immunity to demonstrate an absence of a genuine issue of material fact in dispute. And since they did not do so, our response was, there is no evidence on the issue. So if you're going to consider the complaint, which is one of the species of evidence that Rule 56C permits the court to consider, you've got to consider the answer as well. As I indicated, those are the only two pieces of evidence in the record. And we have obviously a dispute as to what the facts are in the record. She alleges in her complaint that this was reckless conduct, willful conduct, intentional conduct, and the defendant denied that. So,
other than the general description of the conduct that she, in the complaint, alleged additional details such as I complained that they were too tight.
yes, she does. Yes, she does. And she indicates that the handcuffing was, she says approximately 15 minutes when she's laying on the ground, hogged out like this. Mr. Petticourt in his brief said, well, it was only 5 minutes. Well, I'm sorry, there's just no evidence of that at all. The fact of the matter was, one must accept, I think, the reasonably well-planned facts that are in the complaint, and she details exactly what happened to her in the complaint with sufficient detail that this creates a genuine issue of material fact. The trial court respectfully got it wrong and granted this motion without realizing that, even though we specifically pointed out in our brief that there was no evidence to support the contention that statutory immunity did not, or statutory immunity applied in this case. And as a result, I would ask you to reverse and remand to the trial court. And if Mr. Petticourt or someone on behalf of these officers actually files a valid motion for summary judgment, then the issue will be addressed at that point. But dismissing this case under this record, these facts, I respectfully submit it's completely irrelevant. So I will reserve the rest of my time.
Morning, Alex. Please the court, I'm Dan Petticourt, I'm here for Officer Stella and Kucirek, who represent the Lorain County SWAT team. In general, we do not dispute the facts that Mr. English laid them out. We agree that the officers were police officers. We agree that they executed a warrant. As a matter of fact, those allegations in this complaint were admitted in the answer and therefore are facts in the record. That is, in our opinion, crucial to this court's determination because they are the only salient facts in the record right now. The warrant that was executed and sought by the Cleveland Police Department. SWAT was only there in an assistant capacity, which they do from time to time. Mr. English talked a bit about this, but there's no allegation that the warrant was invalid. There's no allegation that the service of the warrant was invalid. The allegation is simply that in the execution of the warrant, his client was injured. I personally, this case comes down to a determination of whether it is my burden to prove that the exceptions to the general grant of statutory immunity do not exist, or if it is the claimant's burden to prove that they do. I believe that the record is clear that the police officers who are executing a governmental duty are entitled to the presumption of immunity. I think that's been the law in the state of Ohio for quite some time. I think there are a number of cases that have been cited to you in our brief and also, frankly, Mr. English's brief that make that point. This case then comes down to his allegations in the complaint, which were denied in the answer, that certain activities were undertaken which amounted to wanton or reckless conduct. I do not believe that the fact that an allegation exists makes it a fact of record for the court to consider the granting motion for summary judgment. I believe that the trial court agreed with that and held that once there was some presumption of immunity attached, it fell to the claimant to prove that one of the exceptions applied, and Mr. English failed to do so. I will agree with Mr. English in that the record is very sparse here. I would say to the court to recall that this incident happened in 2008. This case was first filed in 2009. It was dismissed 2 years later on the day that appellant's response to the original motion for summary judgment was due. It was then refiled 1 year later. There were 6 motions for extension of time either to the discovery cutoff or to our motion for summary judgment that were filed and granted by the trial court before the court finally issued this decision on summary judgment. It is our position that at some point the claimant has to go forward and do something to prove that they are entitled to recovery. To simply sit back and not conduct discovery and not take any action to try and prove the allegations of the case, and then to rely on that failure in the Court of Appeals to say, well, the police officers can't prove that they're entitled to immunity because they can't prove that the existence of a negative, they can't prove that their conduct wasn't wanton or reckless or malicious, is, in our opinion, not in the courts of law. And in summary, that's the extent of our case. It's not a very complex case. Is it my burden to prove that the conduct was wanton, or is it the plaintiff's burden to prove the conduct was wanton? I think that there are a number of cases on that point that you've been provided. I think the O'Toole case, which is not a police case, but which is a failure to report child abuse, talks about that. I'm sure you all have read that. I think one of the more interesting cases here is the McNamara case, which is a Montgomery County Court of Appeals case, where the court did in fact find that summary judgment was not appropriate. In that case, however, the court clearly stated that it was the plaintiff's burden to establish the existence of one of the 3 exceptions, which is our position here. And it stated that one of the ways that you do that is to establish evidence, not allegations, but evidence, that after there was a complaint, the police officers tightened the handcuffs, and that when they put the lady in the car, her shoulder popped out. No, her shoulder popped out. It was the
All right.
Okay, fair enough. I think there's a stark difference here between the case down in Cincinnati, where that happens, and the case here where we have allegations of a complaint that were made 8 years ago, that some unknown officer, it might have been Officer Stella, it might have been Officer Kucirek, it might have been one of the other 12 officers that were sued in the original case, all listed as John Doe's, put handcuffs on Ms. Szefcyk. She found them too tight, complained to some other officer, was ignored, and then complained again, and some other officer loosened the handcuffs. If you take everything that is said in the complaint as fact, and decide to determine that that is evidence, that's the best it gets. That's not enough. That's not enough to prove wanton conduct. That's not enough to prove recklessness. It's certainly not enough to prove recklessness and wantoness against either of the officers who came before you. I don't have much else to tell you, so if there's any further questions, I'd be happy to stand there and answer.
Seeing none, thank you.
Thank you very much, Judge. Appreciate it.
I don't know how much time I have left, but I'm not going to take it. The issue is not quite as simple as Mr. Petticourt suggests. Whatever the past litigation history is not part of the record, it's not something that the court can or should consider, and notwithstanding that, let me just say that. Secondly, the issue in this case, it wouldn't, if what Mr. Petticourt says is it's hard for us to prove the negative. I don't think that's what the issue is. If they are asserting immunity, it is not very hard for them if in fact they were immune, if their conduct wasn't reckless, intentional, and malicious, to have established that with appropriate affidavits or whatever forms of evidence that Civil Rule 56 provides. Instead, they just said, this is what we think the evidence is, and thus the court should decide this motion on this basis. We responded saying, no, au contraire, that is not what the law is. It's your burden to establish at least a prima facie case. And this argument that somehow, since we're entitled to a presumption of immunity, we have no burden when it comes to a motion for summary judgment is fundamentally wrong. Defendants assert let's say, a defense of statutory immunity in their answer. Are they really entitled to summary judgment by simply saying, we asserted statutory immunity in our answer and without setting forth any facts to support our contention that we're statutorily immune, and notwithstanding the fact that the complaint says exactly the opposite and details why this is reckless and malicious and intentional conduct, we are entitled to summary judgment? Because that's essentially what happened in this case. There's a motion for summary judgment that doesn't even address these issues. And then there's a brief in opposition pointing out that there is no evidentiary basis on which this judgment can be made. And we have the court making a decision that somehow statutory immunity prevents my client from proceeding. And with all due respect, that is not the law. And I'm not saying that at the end of the day, Mrs. Szefcyk will win or will not win, but she is entitled to her day in court, particularly in light of the nature of the motion that's filed in this case. So I would ask you to reverse. Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides, all sides, as well as posted on our website, linking you to the Ohio Supreme Court website. Thank you. We are adjourned until Tuesday.